Okay, all right. Now this is week number 3 for our class, Call 126, the 8 cases that changed America. In the first week, back the week of April 3rd, we had an orientation in our first 2 meetings together, in which I basically set the parameters for the nature of the times in which these cases were all litigated. This is the so-called 60s. I pointed out to you that the 60s didn't actually happen all in the 60s, that they basically started in 1965 and went through to 1975, and that the kind of major beginning of that period was, of course, the assassination of President Kennedy in November of 1963. And it reached kind of a high peak. The first high peak of it was in 1968. And I pointed out that's when I started in 1967, started law school in the fall of '67, and was there in that halcyon year of 1968 that I pointed out to you that there were all kinds of major things that happened then that were very disruptive. The assassination of Martin Luther King in April, the assassination of Robert Kennedy in June, the withdrawal of Lyndon Johnson from the presidential race, the huge confrontation that happened at the Chicago Convention, massive disruptions, major student strikes across the country about the war in Vietnam. That was in the opening year of 1968. In our second week of classes, the week of April 10th, I began talking about some of the major cases that I actually litigated during this period. We started with Eisenstadt versus Baird, relating to the right of unmarried people to have access to birth control, and implicitly, as was stated in many of the holdings of the cases, the right for unmarried people to use birth control and engage in sexual relations without being criminally sanctioned for that. And it was a major played a major role in the women's liberation movement of that time, one of the major issues that were going on in the 1960s. I pointed out a number of other issues that were going on. We're moving now into the third week, and the 2 cases that we're going to be addressing this week are going to be the In Re Pappas and its attendant cases, the right of journalists to protect their confidential news sources, and the Pentagon Papers case. Now, these are going to be touching on a number of the other major issues that were salient in this period of time. The issue of major Black Panther activity, black liberation movement that accompanied the women's liberation movement, the challenge to the war in Vietnam, and the confrontation on the part of the media against a lot of the kind of reactionary policies and stuff of first Lyndon Johnson and then Richard Nixon. So these issues of the Black liberation movement, the war in Vietnam, and the media are going to be sort of the issues that are going to have our attention during the course of this week. Before we get to the particulars of In Re Pappas and the right of journalists to protect their confidential news sources, I want to point out a feature of the cases that we've dealt with so far in the course, and I want to direct your attention to a specific aspect of those cases, the Eisenstadt versus Baird and Roe versus Wade, and that is this, is that I want you to notice the severe split that took place in the court at the Supreme Court level in those cases, where you got a very pronounced articulation of a liberal or progressive worldview on the part of some of the justices, like Justice Brennan and Marshall and Douglas and others, and you got this very reactionary perspective on the part of some of the other judges, Rehnquist and Berger and some of the others, Blackmun upon occasion. And that they're, in addition to these 2 kind of highly intense and principled positions that were articulated on the court in specific opinions, there were concurring opinions in each of those cases. One of them written by Potter Stewart and the other one written by Justice Blackmun and White, in which they tried to avoid, in the concurrence, they tried to avoid the kind of hyperbole of the two other positions that were being articulated, in which they were saying, look, it isn't really necessary to make any kind of grandiose pronouncements of high-flown constitutional theory. We can resolve these cases with a much more kind of prosaic or mundane kind of analysis of whether or not the state actually, met its burden of proof in a particular way. And what we saw is that in these two major cases, the Eisenstadt versus Baird case and the Roe v. Wade case, a major issue arose in which there was a fundamental dispute between the liberals and the reactionaries, or the progressives and the reactionaries, having to do with this fundamental question of when in fact there comes a clash between the purported rights of an individual citizen and some asserted legitimate interest on the part of the state or the collective, how is the balance to be struck when there's a head-on confrontation of that nature between these two asserted sets of rights? The progressive element has consistently maintained that in those types of frontal confrontations, the contest is supposed to usually go to the individual citizen, unless the state has been explicitly delegated a very narrow, specific power to do something which is understood to be able to compromise the exercise of fundamental rights. So that the progressives maintain that, look, it's an easy test here, is that you just look to see if there's a fundamental right that the citizen has. And if that's true, then you have to impose a burden upon the state to prove that its exercise of power against this particular person that impinges upon the exercise of their fundamental right has to be absolutely necessary on the part of the state in order to effectuate its legitimate government interest. And there can be no other more narrow way in which it can be effectuated without infringing upon this right, but that it has to be a compelling, overwhelmingly important government interest in order to prevail. Now, on the other hand, the reactionaries have always said that when in fact you have a clash between the fundamental rights or the rights asserted on the part of individuals over and against the state, it's a very simple test. You just find out whether the government is exercising a legitimate source of authority that it's got. And if it's asserting a legitimate source of authority, then the individual right has to give way. Now that, of course, is a very old and very traditional position. It's actually been advocated by every king in authoritarian government that's ever existed, is that if the government wants to do something and it's interfering in your freedoms, you lose. And so these moderates, such as Potter Stewart and Blackmun and to some extent Whistler White, they would come in and say, look, let's just take a real narrow look at these cases and decide, what's the practical kind of pragmatic thing to do about this. Let's not have a clash of high principle here. And that they tried to resolve them in that way. Sometimes there were enough progressives that they were able to muster a clear majority of 5 in order to prevail, or sometimes there was a reactionary majority. But in these two particular cases, there was not a majority of reactionaries or progressives, and so the decisions made by the pragmatists, the concurring opinions in those decisions, are what you have to take a look at to really understand, aside from all the high-blown rhetoric on both sides, what the real resolution of the case was. Okay, but as I said to you before, that's a little bit law schooly, and this isn't intended to be a law school course, even though I'm sure the vast majority of you are going to be going to law school if we succeed in this course. But what I want to do is I want to turn. Now, we've had some discussion about 1968, that big halcyon year. We've had these two cases that came in 1969. And now we've got this case that came in 1970. This is the journalist's news privilege case. I pointed out to you in the earlier discussion that I had become starting in the fall of 1968, I had become the co-editor of the Harvard Civil Rights Law Review, which myself and Mark Green began at Harvard Law School. And I had solicited a lot of applications from different lawyers around the country for important constitutional issues that they thought they might need some assistance on. I had pointed out to you that one of the cases that I had done was the one at the request of this young lawyer, John Flim, in Boston, when the Boston police were going around arresting members of the Black Panther Party that were distributing the Black Panther newspaper on the street corners. And as you recall, I pointed out how the Boston police, anytime there was an all-points bulletin that was sent out for a young black male, robbed a drugstore or did some kind of crime, the Boston police would sweep out and arrest all of the people selling the Black Panther newspaper on the corners, saying, well, he's black and he's a male, and so that's close enough. And they would hold them all day, put them in lineups, hoping that they would be misidentified for something, and they put them in a dozen lineups during the course of the day on a dozen different crimes. And then at the end of the day, after they'd not been identified, they would in fact have lost all of their Black Panther newspapers. And I pointed out to you that I'd had that other case that was the Panther bombing conspiracy down in New York, the Panther 21 case, where the harassment began on the part of the Boston police, or the New York police in that case, resulted in a shooting of a police officer, and then there was a huge sweep of the leadership of the Black Panther Party into custody and a huge prosecution of the top 21 leaders of the Panther Party in New York, all going on in 1970. So this kind of intense conflict between police and the militant black movement, liberation movement, was very intense in 1970. And so I got a call because what had happened is in 1970, after I'd done these other cases and had drafted the motions that got the injunction against the Boston Police Department, stopping them from doing this illegal arrest of the Panthers, an event took place out in New Bedford, Massachusetts. And I touched upon it briefly, but today is the time for going into a little more depth on this case. This is a case where in New Bedford, Massachusetts in 1970, a lot of tension was in the air because of these confrontations between the Panthers and the black community and the police. And what happened is a young black militant from New Bedford, a fellow by the name of Warren Hautman, was stopped by the New Bedford police. And this took place after another young man had been arrested a couple nights earlier. A young black man had been taken into custody by the New Bedford police. And the community rose up and all began to demonstrate at the Central Police Department in New Bedford, chanting against the police and insisting that they let this guy go. And what happened is one of the people that was in the vicinity was Warren Hautman, who the police had identified as a black militant. And they pulled him over and stopped his car, allegedly for a tail light, a malfunctioning tail light on his car. Now this is kind of a paradigmatic, a classic of the police. When they really want to hassle somebody, they say, oh, you had a tail light out. And so they had to pull you over, then search your car, and then search you, and then do a cavity search, and they go on to the whole line until you basically resist them, and at which point they go after you. And that's what happened with this guy, Warren Hautman. He was arrested for driving a vehicle with a defective tail light. They then arrested one Charles Perry, a friend of his, who was in the vicinity of where the car had been stopped. They charged Charles Perry with aiding a young woman to escape from the police, who they were attempting to arrest as a material witness, to try to get her to be a witness against Warren Hautman. So they arrested two of the most militant members of the black community on that one night. And then another fellow by the name of Jimmy Magnat started organizing and started holding meetings down on Kempton Street in New Bedford. And a lot of the youth from around the city were coming to this meeting. And he began to rally them all up and get them cranked up. And the mayor got very upset. He sent the police in, and basically a major fight ensued between the militants that were there at the club, they called it, on Kempton Street, and the police. And a melee broke out. And because of the kind of tinder box quality that summer, the people in the community all rose up and a big riot started against the police. And burning started happening, looting, turning over cars. And the mayor of New Bedford, receiving reports that there were firemen going into the area where the shops had been set on fire, and that they were being attacked. They had people throwing stones at them and garbage cans and stuff. And so and then looting was going on. And so the mayor issued an order for the New Bedford police to shoot on sight any looter. And when that happened, the senator, the United States senator from Massachusetts, at that time Senator Edwin Brooke, the only black senator in the United States Senate from Massachusetts, went to New Bedford and tried to calm things down. And also 7 members of the Black Panther Party from Boston arrived in New Bedford at the same time. And they began holding rallies and meetings. And the mayor declared them to be outside agitators. And he declared them to be the cause of these riots. And he had the county district attorney impanel a special grand jury. Now, it hadn't gotten set up yet, but what had happened is the Black Panthers organized and they set up roadblocks all around the ghetto area in New Bedford to keep the police out and to keep the firefighters out. And they began to establish kind of a community law enforcement operation in the ghetto to stop the rioting, to stop the looting, but they wouldn't allow the police in who were under orders to shoot on sight any looters. And a young reporter, a television journalist by the name of John Pappas, was sent from the NBC local television station to go to the barricades that had been erected around this major place that they called the club that was on Kempton Street. And he was attempting to get the people from the Black Panther Party to tell him and to tell the NBC viewing audience what the reasons for this riot were and what were their objections and what were their protests. Now, as is reported in the Encyclopedia of Race Riots, there's actually such a book, the Encyclopedia of Race Riots, which you can find on Google. Page 453 to page 457 recounts this riot that took place in New Bedford in 1970. And they point out that the causes of the riot were, it said, they actually listed it to, similar to the issues that animated riots in hundreds of black communities throughout the country between 1963 and 1970. That's their quote. It was high unemployment among black youth, inadequate public education facilities and teachers in the ghetto areas, poor housing in the ghetto areas, a shortage of public recreation space, and police brutality had always been a major theme of these protests that were going on during these summers. And so what happened is when John Pappas tried to get these Panther people that were armed, they were behind the barricades and they were holding off phalanxes of local police, county sheriffs, Massachusetts State Police, heavily armed snipers were up on the roofs everywhere. And John Pappas was trying to get the Black Panther people to tell him what was going on and what their protest was all about. And it wasn't that the Panthers had started these riots. In fact, the Panthers hadn't come in from Boston until 3 days into this rioting that was going on. but they had shown up, and Pappas was trying to get them to tell him. And every time he would crank the cameras up and get them on the Black Panthers and start trying to go talk to them, and the Panthers realized that the television cameras were on them, they would all leap out and go, "Fuck you, honky, fuck you," like that, and ruin his footage, so that you couldn't really put that on the evening news. And so that he was getting very frustrated, not being able to get them to agree to talk with him. And later on in that day, at 9 o'clock, the Black Panthers had come to the conclusion that the police, the Massachusetts State Police and the police from New Bedford were going to launch an attack on their headquarters here at the club on Kempton Street. So what they did is they sent a guy out to talk to John Pappas and say, look, here's the deal. We're going to allow you to come in. You can come through the barricades. We'll allow you in with your camera team, but it's on a specific agreement that you, in fact, are not going to talk about anything you've seen or anything you hear or name anybody that you've seen in here unless there is an attack on our headquarters, which we're assuming is going to happen. You can come in, you can talk to anybody you want. If they feel like talking to you, they will. If they don't feel like talking to you, they won't. But you can record and tape anything you want. And if in fact the police raid takes place, then we want you to be sure to film the police raid to show what they're doing. That we haven't attacked them, we haven't done anything, that they're attacking us. And in the event that such a raid takes place and you film it, then you can use whatever you want that you've filmed as part of your story. But if there is no police raid, you have to keep it and hold it on deep background and not show it to anybody. And this will be a deep background set of interviews. And so Pappas leaped at that opportunity. He contacted his NBC superiors in New Bedford, and they agreed to that. So in he went, and he was in there throughout the evening interviewing them, and some would talk to him, some wouldn't. He had pictures of them cleaning their guns and getting ready and telling how awful the conditions were in the ghetto and all of that. And it turns out the whole evening went by, and it came the next morning, dawn, and into the early morning, and no police raid took place. So he packs up all of his gear and takes all of his film footage and all of the recordings, and he leaves. And he goes back to the office, and it turns out the police raid happened the following morning. And so the police raid comes in, and they drop tear gas on the place, and they burn the place down, and they shoot the guys up, and they arrest them, and they drag them in. And then this grand jury is convened. In the grand jury, the purpose of the grand jury, as announced by the county district attorney, was to inquire into the potential connection between the Black Panther Party and the cause of the riots. Okay? Now, they had no direct evidence linking the Panthers to this, other than the fact, there was a specific reference made to the fact that when the people gathered around the police department demanding that these people be released from police custody, they started chanting, "Get the pigs out of our community. Get the pigs out of our community." And of course the police said, aha, they're calling us pigs. That's the Black Panther Party. The Black Panther Party are the ones that started calling us pigs, and so therefore this must be instigated by the Black Panther Party. That was the only evidence that they had. And so they convened the grand jury, and the first person they subpoena is John Pappas from the local NBC television station. And they demand that he come in and he tell them everybody that he saw, whatever it is they said, what kind of questions did he ask them, what answers did they give, did he have any kind of evidence, did he see any evidence of any unlawful conduct of any kind, just broad sweeping questions they were asking. And he in fact refused to answer them. And yes?
I have a question.
Yes.
So you were saying like earlier, a couple classes ago, how you defended the rights of Black Panthers, etc., and now you're about to go into like them like fighting for like these rights. Do you think today, now that like the word terrorist has such like a huge connotation, that these people would simply be labeled terrorists, and you guys would all be labeled like terrorist sympathizers and like just shunned from society?
Well, not shunned from society, shunned by the administration.
Right.
There's a difference. You know, and that, yeah, sure they would.
I feel like it's more. I feel like today there's more of like imagine if like people saw you as a terrorist sympathizer. That'd be a lot different than a Black Panther sympathizer.
Well, but what they did is they hadn't had David Addington and John Woo write up all the memos that they wrote under W. Bush. And what they did is they elucidated a specific kind of theory pursuant to which they could characterize people who in fact took militant action against the state as being terrorists. Because when the communist government fell in the Soviet Union on December 31st of 1991, these reactionaries were without some ultimate other. They didn't have an ultimate other pursuant to which they could somehow garner a sense of self-respect by vanquishing. And so they had to go looking around for someone else. And so that strangely enough, they end up seizing upon, somebody like Osama bin Laden, over in the Middle East.
So you think that like at that time, it helped that there was an other in the communists? It helped. You think that?
Well, no. They characterized the Black Panthers as communists. Oh yes, that was the term of the day.
So it's almost what I'm saying, but at that point they called them communists.
That's right. That's right. They were the ultimate other. And it rose to a fairly high frequency back during the McCarthy era, 1954, 1955, that anybody who basically read more than 2 books a year, was characterized as a communist sympathizer. If anybody supported, Social Security, or any kind of, Medicare or anything like that, they were considered socialists. And socialists are the same thing as communists if you don't read. They all have like an ist on the end, and that's close enough. And so that this attitude on the part of the reactionary, the adherents to the reactionary worldview has always been the same. They see anybody who refuses to succumb to the slightest whim of the state as being, a potential militant, a potential belligerent against the state, and they're part of the ultimate other.
Like goes hand in hand with militarization of the police force, and he with that famous quote that when the military becomes the police, then the enemies of the state become the people.
Yeah, no, that's right. And so that what you saw happening here is because of the war in Vietnam, because of the war, well, there were 2 things actually. There's the war in Vietnam, and then there was this social war that was mounted by Richard Nixon against the baby boomers. That one of the first things that Richard Nixon did, and you'll see it becomes pertinent in the third case in this case here is Branzburg versus Hayes. You'll see it. It becomes pertinent because that was basically an issue dealing with marijuana in hash. And so what happened, one of the very first things that happened when Richard Nixon became president, he appointed a blue ribbon commission and asked them to come up with a set of recommendations to strengthen the laws against marijuana. And what they did is they all sat down, had tons and tons of meetings, took tons and tons of evidence, and they came out with a specific official recommendation that marijuana be decriminalized, because the criminalization of marijuana was generating an entire generation of outlaws. That was the term that was used by the Blue Ribbon Commission. And what happened is that because the position that the government had taken was against marijuana was so irrational, and so many people were actually smoking marijuana and then saying, hey, look, if they're going to criminalize me for smoking marijuana, I might just as well be hung for a sheep as a lamb. And so therefore, if they're going to try to draft me, and drag me across, 8,000 miles and put me into a jungle to kill people, shoot hot lead into the bodies of people that have lived there for 500 generations, that were parachuting out of the sky and shooting them and killing them, and you wouldn't be able to find one person out of 1,000 that could even pass a test on why we were there, that I'm not going to do that. And so that a whole percentage of people in our generation began to refuse to respond to the draft. and a whole bunch went up to Canada, a whole bunch stayed here and fought. You know, young women who weren't subject to the draft had boyfriends and brothers, you know, who were being drafted and dragged away and killed, you know, 50,000 guys, you know, being killed, and tens of thousands, hundreds of thousands of people in Vietnam being slaughtered, you know, by American helicopters and stuff. And people were going ballistic about this. And so what happened is that this type of attitude on the part of our generation had its corollary manifestation within the black community, because people who were in the black community who had been subjected to these kind of extraordinary injustices still hanging over from racial segregation. You know, up until 1954, weren't even legally allowed to go to a white school. You know, and weren't even legally allowed to drink out of the same water fountain as white people. I mean, this is 1954. This is only like 6 years before 1960. You know, so that the anger that had built up on the part of the members of the black community, because of the poor educational facilities they had, the kind of poor everything that they had, unemployment, et cetera, that there developed a militant movement in the Black Panther Party to rise up against the state. And they were very specific about the injustice of the state. And they were very specific about the economic origins of the authoritarian policies of the state. And so that they had a very heavy kind of Marxist overtone to the Black Panther literature and newspapers, et cetera. And to be frank about it, even a lot of the major groups that were opposing the war began to get pushed further and further, to the point where they started, you know, quoting Marx and cheering for Ho Chi Minh and cheering for Che Guevara and Fidel Castro, and it actually got to the point where they were taking a certain amount of glee from freaking out the police and freaking out Nixon and all of the constabulary. You know, I mean, and so that they were saying that we're not going to be intimidated by you calling us socialists or you calling us enemies of the state. I mean, they were proud of it. I mean, people would cheer over being called enemies of the state, because they said that you know, if you're not an enemy of this state of affairs, then you know you have no conscience. You know, not only that, you don't basically believe the fundamental principles upon which our country was founded, if you're going to not be an enemy of this state, which is doing the kind of things that it's doing. And so this generated this kind of antagonism between the Black Panthers and the state, the federal government and each of the respective state governments. So it came to a big clash in New Bedford. And so what happened is when Pappas got subpoenaed, he said he didn't want to go. He didn't want to go. He said that just going there and going behind closed doors with a basic grand jury that was dominated by the local district attorney, that was basically fishing for any evidence that they could get to try to hang on to the Black Panther Party responsibility for instigating this riot, when the evidence was virtually non-existent for blaming them for causing the riot. And their leaders weren't even there, as I said, until 3 days after the riots had already been going. And so he said he thought just going behind closed doors was going to destroy his credibility, interfere with his ability to have trust of the people in the Black Panther Party, to be able to report on what their grievances were, et cetera. And so, he contacted his local NBC television station saying, I want you to contact our lawyers, the NBC lawyers, and get an injunction against them forcing me to go to the grand jury, a motion to quash this subpoena. Well, their lawyers, the local lawyers in New Bedford, said, wait a second, there's no such right as that. You know, you don't have any right to not have to go in front of a grand jury. The First Amendment doesn't give you any such right. We don't know about any such law. And so he then asked them to contact the national lawyers for national NBC down in New York. the Cahill-Gordon firm down there, the Floyd Abrams and the people down in the Cahill-Gordon law firm, they too said they didn't think there was any such right. And so he then called the Black Panther people in Boston who had come in to help organize the people in New Bedford, and asked them if he said, I don't want to go. I want you to know that I don't want to go. I don't want to respond to this subpoena, but you got to get me some help because I can't get my lawyers to help me. And so they said, wait a second, there's this guy, John Flim, who is the guy who filed the motion to get a protective order on behalf of the Black Panther Party last year against the Boston Police Department, going around arresting all of these distributors of the paper. So they called John Flim, and John Flim calls us. And he said, look, you're the guys that actually put together the motion for the protective order. Can you help us on this? So we drafted up a motion for a protective order, which they filed with the supervising court out in New Bedford. The Superior Court judge said, absolutely not. I've never heard of any such right. You got to testify. Pappas still refused to testify. So we invoked that process that I told you about before, where you can move a question, a constitutional question, all the way up really fast to the Supreme Court of Massachusetts. We did that again, and we got up in front of the Supreme Judicial Court, and they said, no, there's no such right. And then what we did is we petitioned immediately for the issuance of a writ of certiorari in the same way that we had in the Eisenstadt case to the United States Supreme Court. And the United States Supreme Court said they would grant it, and issued an order to send all of the record and everything up to the United States Supreme Court. So there we were. We had the second case in front of the United States Supreme Court, and that I was now a third-year law student at Harvard. And so, and Pappas said, we got all the way to the Supreme Court, and then the Cahill-Gordon firm, Floyd Abrams and Jack McKay, contacted the local NBC station and said, okay, we'll do it. We'll argue the case in front of the Supreme Court. And Pappas said, no, you won't. You're the ones that told me there wasn't any such right to begin with. You know, I'm going to have these kids from Harvard Civil Rights Law Review, they'll do the case for me. And so we did. And so they were freaking out down at the Cahill firm, saying, look, this is $1 million lawsuit. You know, the New York Times and the NBC and everybody else are going to be wanting to file briefs on this kind of thing. We can make a mint on this. Who the hell is this kid at Harvard Law School? And why don't we go see if we can get him? And so they did. And I told you that little funny story where Jack Armstrong came and interviewed me and realized I was on my resume that I was in the Black Harvard Law School Society, and he was terrified that I was black. And besides, I was helping do this stuff for the Panthers, and so that he assumed, well, that had to be true. Why would an Irishman be doing that? Figured that Jack, being an Irishman, should have known why. But so the bottom line is they ended up recruiting me to come to the Cahill firm, which is this big, huge, powerful 178 trial lawyers on Wall Street that are the #1 litigation law firm in the world. And so I get to go down there, and as I mentioned to you, I cut this special deal that in light of the fact that I knew I had some leverage here, I said, look, I have to have a deal that you're going to allow me to spend half of my billable hours working on public interest cases, which, as I said, they assumed was going to be like suing some furniture company. You know, if somebody buys a couch and pays all the bills but one, and then they come and take his couch away, you know, and it turned out to be something rather different. And so we had this case up in front of the United States Supreme Court when, lo and behold, I get a call from Tony Amsterdam. I was down in the firm. Now this is June of 1970. I'm down in the firm in July 1970, and we're preparing the motions on the Eisenstadt case that I'd already done. That was up in the Supreme Court. We had this one now here, and I was preparing all the briefs, and I was writing the amicus briefs. This was all on behalf of NBC, who was the client of Cahill. But the New York Times wanted to have amicus briefs filed. CBS wanted to have amicus briefs filed. The Washington Post wanted to have amicus briefs filed. So they had our law firm, since we were the #1 litigation firm in the country, preparing all of the briefs. And since the rest of the people in the staff didn't believe in the right to begin with, I got to write them. Okay?
What's an amicus brief?
An amicus brief is what they call a friend of the court. They're people who, or organizations that have a very similar interest to the client that's up in front of the Supreme Court, and that they want to be able to weigh in by providing information to the court about what they think ought to be done in resolving this case. So I was doing all of those things. Yes.
What prompted the Supreme Court to grant you certiorari review? Did you get the luck of the draw, Justice Douglas and another couple liberals on the initial?
It's a 4. They call it the rule of 4. If 4 of the 9 justices want to take a case, that they will do that. And so we had, of course, in this particular case, we ended up having vote for giving us certiorari. We had Justice Stewart, Justice Brennan, Justice Marshall, and Justice Douglas all said they wanted to take the case. So we had the case up in front of the Supreme Court, and I was writing the amicus briefs for all of these other groups when I get a call from Tony Amsterdam. Tony Amsterdam was a young attorney who was teaching constitutional law at Stanford Law School. And what had happened is the Black Panthers were having a rally in Los Angeles, and one of the fellows, David Hilliard, one of the Black Panther guys, was up delivering a speech about Richard Nixon, and he said, in front of like 350 people, 200 of which were FBI agents, he said, "Lee Harvey Oswald, where are you now that we need you?" And so these guys go berserk in the audience and leap up on the stage and drag him off the stage and arrest him for threatening the life of the president. But not being willing to just accept that, they then impanel a special federal grand jury to investigate the Panthers for potential conspiracy to assassinate Richard Nixon. And so the first guy that they subpoena is this guy, Earl Caldwell. Earl Caldwell was a young black reporter for the Los Angeles Times who in fact had developed a relationship with people in the Black Panther Party, which, as you may remember, started in Oakland. And he was able to interview them and knew them by name, and he was very familiar with them, and he'd been writing a series of articles in the Los Angeles Times about the whole rise of the black militant movement. And so the U.S. attorney in Los Angeles says, well, this is a handy guy, let's get him. And so they issue a subpoena for him. And so he calls the Los Angeles Times lawyers and asks them to represent them. And he's saying that they're saying, oh, well, you know, the amicus brief working out our position on this thing is still being written by the Cahill firm, so we don't know exactly what position to take. And so Earl Caldwell calls Tony Amsterdam over at Stanford Law School and asks him to represent him. And Tony Amsterdam calls me, and so I'm sitting there on the phone with him, and we're figuring out how to write these briefs, how to get a spread of positions on the part of all the different amici to take a position on this thing. And so he said what he was going to do is he was going to take a position that Earl Caldwell didn't even have to appear in front of the grand jury. He didn't have to file a motion to quash. He didn't have to appear. He didn't have to offer to answer anything at all, that he had an absolute, total, impregnable First Amendment right not to appear. And until such time as the Justice Department articulated exactly what the questions were that they were going to be asking and made it clear that it wasn't going to be seeking any information that he'd obtained from a confidential source, and wasn't going to be trying to find out the names of the confidential sources until the government met that burden ahead of time, that he didn't even have to show up to the grand jury. And so he went to the district court, filed a motion in front of the federal district court in Los Angeles, asking for a declaratory judgment and an injunction, and he won. The federal district court in Los Angeles ruled that the First Amendment right was so sensitive and so important that he had a right not to appear at all, respond in any way, and that until such time as the federal government demonstrated what the information was they wanted, that they were unable to get it anywhere else, that it was that they had probable cause to believe that a specific crime had been committed, and satisfied the court that probable cause existed, that he did not have to appear. Okay? And so he won that, and then it went up to the Ninth Circuit Court of Appeals, and they affirmed the district court and wrote a great Ninth Circuit Court of Appeals opinion in which they laid out what is basically Justice Douglas's position that you read for today. And so that we had a second case then up in front of the Supreme Court. And I was writing the briefs for the New York Times and the Los Angeles Times that were their amicus briefs, which were then, I was trying to get them to support what the court had said in Los Angeles, and they wouldn't do it. You know, so the lawyers, the Royal Cagle firm for the New York Times, found themselves in the unenviable position of having declined to argue a position which the court that they were in front of was willing to give them. And they wouldn't argue it. Okay? And because they said, oh, well, they didn't think the Court of Appeals was going to agree to it. They go up in front of the Court of Appeals, and they wouldn't argue the point even in front of the Court of Appeals, who said they would give it to them. And so the Royal Cagle firm was in the major doghouse by this time with the law firm, or with the New York Times, and with their reporters, et cetera, which opens on to the issue of why we took the client away from them in the Pentagon Papers case. We'll talk about on Thursday. But so all of this happened. So in this particular case, we've got two cases now up in front of the Supreme Court. We've got the In re Pappas case, all involving the Black Panther Party, and the attempt on the part of the county district attorney in New Bedford to engage in this open-ended fishing expedition, trying to find out any kind of information to tie these people to the riots, right? It had been denied by the Superior Court, it had been denied by the Supreme Court of the state of Massachusetts, and it was on certiorari up in front of the United States Supreme Court now. And we had a second case, which also involved the Panthers, out of Los Angeles, in which the district court, federal district court, had agreed that he was totally protected, and the Circuit Court of Appeals, the Federal Circuit Court of Appeals had agreed. And so both of those cases were up in front of the court. And then the court did a very interesting thing. They reached out and they took a third case. And this is the Branzburg case from down in Kentucky. And in that particular case, there were a series of articles. The Kentucky Courier-Journal wrote a series of articles in which they were reporting on marijuana smoking going on in Kentucky. And that there was a group of people that were actually making hash out of marijuana. And one of their reporters had actually gone in and interviewed them and hadn't shown their faces on the camera, but was interviewing them about what this was like and what the culture was like about marijuana and what was going on. And the Jefferson County district attorney impaneled a grand jury after he saw this on the television and subpoenaed the journalists and demanded that they come in. Now, in this case, what you had was a direct videotape of people committing a very specific federal and state crime, right? And so in this particular case, it turns out the journalists, realizing that this issue was up in front of the United States Supreme Court, they asserted the right not to be compelled to reveal the identity of these people, saying that they were their confidential sources. And so the judges, the four reactionary judges on the Supreme Court, just said, oh boy, here's a great case, let's get this one. And so Justice White and Berger and Blackmun and Rehnquist, supported by Powell, said, let's bring up a third case to join together with these Black Panther cases, both of which are fishing expeditions, with a case where there's a direct, absolute proof of a criminal act, where the journalist is overstepping and saying he's invoking the right of a confidential source when he's videotaping a crime taking place. And that's what they did. And so they bring the third case up, and as you can see, they designated all three of these cases as Branzburg v. Hayes. So they led with that third case. And you can see in the opinion that was written by Justice White, he starts right out talking about Branzburg and lays out this whole big long thing. And then what he does is he launches into an analysis about how clearly the First Amendment is not an absolute right. And he starts basically backing up into the same kind of argument that was made earlier in Eisenstadt versus Baird by the reactionaries. That Rehnquist, you remember, Rehnquist had made this argument that the Fourth Amendment, the right of privacy that was at issue in Eisenstadt versus Baird and in Roe versus Wade, is not an absolute right. If you recall in his dissent, the Fourth Amendment, right of privacy, even though he doesn't think it includes the right to an abortion, he said this whole Fourth Amendment, in the Fourth Amendment it says, people shall be secure in their person, places, and effects against unreasonable searches and seizures. And they shall be subject to search and seizure only upon the issuance of a warrant that is issued by a magistrate based on probable cause to believe that a particular crime has been committed. So it was obvious to Rehnquist on the face of it that the Fourth Amendment, privacy right at least, was inherently a balanced issue, and that it was only sacrosanct to a certain degree, and that if a reasonable argument was made that the privacy had to be compromised in order to find evidence of a particular crime, the way that it was set forth in the Fourth Amendment to the Constitution made it clear that that balancing could be struck. But Justice Douglas, as you see in his dissent here in the In re Pappas case, he says that's not true about the First Amendment. The First Amendment is set forth saying Congress shall pass no law restricting the freedom of speech or freedom of press or freedom of religion. That you can't just balance that away. It's not like the Fourth Amendment, okay? But what happens, Whizzer White starts right out, joined by Blackmun and Rehnquist and Berger, the reactionaries on the court at that time, and he starts laying out all of what he asserts to be the obvious restrictions that have been placed on the First Amendment. And they'll go through things like, well, you can't shout fire in a crowded theater. A libel law, the press isn't free to just write scandalous libels knowing and willful lies about people and ruining their reputation. And he says they also say the National Labor Relations Act having to do with labor unions is applied to newspapers. And the Sherman Antitrust Act is applied to newspapers. So I mean he comes through all these kind of weird tangents to try to show that the right to freedom of the press has, in fact, had limitations placed upon it, the way he perceives it. And so he and Berger and Blackmun and Rehnquist have a four-person plurality that you'll see in this opinion. And you'll see that the progressives on the other side have a four-person dissent, which is Potter Stewart, William Brennan, Thurgood Marshall, and William Douglas. They all dissent. And they say, wait a second, Douglas has his own concurrence in his dissent, or his supplemental dissent. He lays out a clear articulation. You aren't going to find a better, clearer articulation of what the proper standards are that ought to apply to First Amendment expression than this dissent written by Justice Douglas. This is worth carrying around in your pocket or putting it in your backpack to carry with you, along with your copy of the Constitution, which I hope you all are going to have. We'll get copies of it for you. We'll get these little copies you can carry with it and flash it out in your midnight discussions that you're having about these, because you're so enthralled with these particular subjects, right? But anyway, and the dissent Potter Stewart in Brennan and Marshall is the proper analysis about any type of test that needs to be applied if you're talking about having any constraint against the First Amendment at all. Douglas writes that there should be none at all, but the additional dissent by Stewart and Brennan and Marshall lay out this test that I've talked to you about before. If in fact the state asserts that it needs to exercise one of its legitimate powers and it infringes upon the exercise of free speech, there is a test that the state has to meet at the threshold. And that is, it has to show that its motive in attempting to do whatever it's doing that's having a negative impact upon the exercise of free speech or free press has not been undertaken for the purpose of chilling the free press or free speech. Secondly, it has to show that the interest that it's pursuing is not just any old interest, but it's a very powerful and compelling government interest. And thirdly, they have to show that the interest of the government cannot be effectuated in any other way that has a lesser negative impact upon the exercise of that free speech or freedom of the press. That they have to do that, okay? They have to meet all three of those standards before they're allowed to engage in an activity that has this kind of adverse impact upon freedom of the press or freedom of speech. And so that what Stewart and Brennan and Marshall said is that that clearly has not been done in this case. And they go on to point out, pointing to the Panther cases, pointing to the two Panther cases, saying, look what they're doing here. They're basically going on a fishing expedition. They don't have any probable cause to believe that a crime has been committed. They've gone fishing. What they're doing is they're trying to deputize the person from the free press to be an investigator for the state. And that is inevitably going to chill any other source that wants to talk to the free press, because they can be turned into an investigative agent for the state simply by the district attorney issuing a subpoena to the person. You know, a perfectly cogent argument that they're making here. And so they lay this whole thing out. But what you see over and over again is that Berger and Rehnquist and Blackmun and White, they keep retreating to the Branzburg case. Wait a second, you can't possibly be saying that a journalist has an absolute right to be going and videoing a crime being committed and then can't be compelled to tell the grand jury, you know, who those people are, you know. Now, this raises another question, and Douglas addresses it, and so does Stewart in their dissent. This has to do with the issue of the grand jury. Now, and this is a little bit ancillary, but I think it's important for you to know. The grand jury at common law developed as a shield on the part of the people against an arbitrary and capricious king and the king's man, who was the prosecutor. Because the king would arbitrarily and capriciously arrest people and charge them with false things in order to coerce them to pay them more money or give up their land or do things like that. And so what happened is the people ourselves organized and put together people's grand juries of 24 people. And they were saying that, look, before the king's bench can indict anybody or can charge anybody and bring them to trial in front of the king's bench, they have to present their evidence to 24 independent citizens. And the citizens have to come to a conclusion, not the same thing as a jury, that is clear beyond a reasonable doubt that the person did it. But they have to be able to determine that based upon the evidence, it is more probable than not that that citizen has committed this crime. And therefore, it's appropriate for the king's prosecutor to bring that person in front of a jury and put them to the test, or put the defendant to the test and the state to the test as to whether or not they can prove beyond a reasonable doubt that the person did it. That's the job for the jury trial, okay? But what happened is over the years, the king's prosecutor, since they're the ones that are going to be coming into the people's grand jury and presenting the evidence, it turns out they were the only lawyer there. And so that what they ended up doing is ended up getting appointed to be the attorney for the grand jury. And so that they ended up coming in and presenting all the information. They would hide information that was exculpatory or tending to show the innocence of the person. They wouldn't put on any of the witnesses that contradicted any of their witnesses. And they would just come in and they would parade the one-sided part of the case in front of the grand jury and then would say, look, I'm your lawyer. I'm advising you to indict them, you know, which is what I want done. And worse than that, what they started doing is using the power of the grand jury to ask questions. And they began to use the grand jury as an investigative tool of the king's prosecutor. It was a total distortion of the common law purpose for the grand jury. And so what they did over time is they began to turn the shield against unfair prosecution into a sword on behalf of unfair prosecutions. And that they would, but you know, if they called you into the district attorney's office and said, look, you better tell me what the answer to this question is, you know, like all these police shows you see, the interrogations, you know, your friend said you did it, you know, we've got your fingerprints on this thing, you better confess and I can help you get a better sentence, blah, blah, you know. But if you just said, you know, piss off, you know, I'm not going to talk to you, I'm going to assert my Fifth Amendment right or whatever it is, you know, then they couldn't do anything. But so what they do is they put you in front of the grand jury. And if you refuse to talk to the grand jury, they hold you in contempt of the grand jury because the grand jury has kind of an alleged independent status and you're offending the people as distinct from offending just the state or the king's prosecutor. And so that's what these people were doing in this case with regard to both of the Panther cases. They were using, the district attorney was using the grand jury as an investigative tool of the prosecutor's office to try to dredge up any evidence that they could against these people. And that's what Douglas and Stewart point out in their respective dissents as an additional problem here. And there were a couple questions though that the folks were asking here too. Yes?
How do you feel about prosecutors being immune from persecution for deliberately and purposely withholding exculpatory evidence against people?
I think they should not only be persecuted, I think they should be prosecuted. In fact, because they shouldn't have immunity. That they are engaged in abusing. They're going beyond their constitutional authority, and once they move beyond their constitutional authority, they're functioning as a private citizen. They're pursuing their own ego. They're pursuing their own career objectives. They're pursuing something that is over and above the limited power that has been delegated to the state by the Constitution. We come back again. We hit upon this same issue. You need to understand that the federal government and by the 14th Amendment, derivatively, the state governments have only the specific power that has been expressly delegated to them by the people. And that when any agent of the state goes out beyond that and starts functioning beyond the power that has been given to the state by the Constitution, that person is vulnerable. And the reality is that we've been able to carve our way into getting at most everybody else. You know, we can get at police officers, we can get at, high school principals, we can get at, all kinds of state officials, IRS officials, we can get at everybody. But the prosecutors, lawyers, all club up and they protect the prosecutors and they protect the judges. Judges and prosecutors, they say, have to be left with unfettered discretion, in that they can't constantly be looking over their shoulder about someone prosecuting them just because they made a mistake. And so that's the problem that we've got. There was a little flutter of a hand or two. Okay, so what else?
No, I think there's a difference between committing a mistake and purposely withholding evidence that.
Oh yeah.
lets the defendant go free.
Clear this up.
And prosecutors do that all the time.
Clear this up. There's been a major study has been done this past year in 2011, and that they've come to the conclusion that from 40 to 50% of the cases that are prosecuted have one or more serious acts of prosecutorial misconduct. You know, they suborn perjury all the time. They coach their police witnesses all the time. Police, you know, plant evidence, make up stories, are caught red-handed in the middle of blatant perjury, you know, and no one will prosecute them because they're all part of the same team. It's all part of the state, which is one of the reasons why, I mean, a person, you know, of a philosophical bent, you know, is inclined to say, look, we ought to be fairly even-handed here. When we find these kind of confrontations between the state and the individual, we should be even-handed. We should try to figure out, you know, what a reasonable balance of this thing is. You know, no, that's not true. The fact of the matter is, this isn't just, you know, weighing rice bags. You know, the state is invested with dangerous power. Dangerous power. In the entire theory of the Constitution of the United States is rooted in the premise that you should not trust the government. That the government is inherently to be distrusted, because if you give them the power, they will abuse it. And so that you have to constrain their exercise of that power, and the bias has to be against the exercise of power. They have to overcome an additional special burden that they have to meet. And you don't have to feel sorry for prosecutors. You know, they've gone there because they think they're going to be president of the United States someday. You know, every prosecutor you ever want to meet, you know, from every assistant district attorney to district attorney, they all think this is the stepping stone to becoming the mayor, to becoming the governor, to becoming the senator, to becoming president. And so that's what they choose. And if they choose that, fine. But they've got a special burden that they have to carry because they wield the power of the state. You know, and you need to never let go of the understanding that the Constitution has been rooted in the premise that the people have the benefit in the balancing between the two of them, that the individual liberty always has to be given higher preference. And so there's an additional burden that the state has to make and meet. And what the problem is with Berger and Blackmun and Rehnquist and these other people, they all treat this like it's a checkers game. You know, hey, wait a second. You know, you get to move, I get to move. You move, I get to move. You know, but that's not what it is. You know, they're supposed to have a special additional burden that they have to meet, and you don't want to listen to them whining and crying, and you certainly don't want them to be able to invoke your basic decent sense of justice. You know that everything ought to be fairly balanced. Whenever there's two sides contesting, you ought to be completely neutral in this. That's just not true. In this particular case, because of the kind of power that they have, that the scale has been intentionally weighted against them and on behalf of the individual. And it's that you know they don't agree with it, the reactionaries, you know, but better that you know that 9 guilty go free rather than 1 innocent be sent to the electric chair for something she didn't do. You know, and that's a principle of the government. Okay?
Is that in the area of constitutional rights and police and those kinds of things?
Yeah.
Or is that different when it comes to services like health care and things like that?
Well, as long as the agency that is providing services doesn't cross over into violating what are understood to be fundamental rights. And that's what they do, you know. And now that raises again that question. I want to start just having more questions here back and forth, but the question of how we go about designating what is or isn't a fundamental right over and against the state so that this special burden falls upon the state. I mean, if the state is doing nothing more than than asking you to do something fairly reasonable and understandable that doesn't seem to offend people, doesn't carve into any kind of area of real privacy or anything. If, for example, they're asking you to stop at red lights, when you're driving, that there's a fairly rational system that they've got red lights set up and people take their turn going. The fact that they're asking you to do that, it's not like you're being arrested by a red light. It's not that your freedoms are being significantly interfered with, even your right to freedom to travel. But when in fact they say things like, for example, like they've suggested today, and you ought to take a look at this. I got called today. I haven't looked at it yet, but somebody called me and said that Harry Reid has put in a proposed piece of legislation today to authorize the director of the Internal Revenue Service to revoke the passport of any American citizen who the IRS suspects of not having paid their taxes up to or over an amount of $50,000. If the IRS inside its own shop develops a suspicion that you somehow you are in arrears over $50,000, the IRS director can yank your passport, and stop you from traveling. You can't fly out of the country. You can't drive out of the country. You can't, that is outrageous. That is outrageous. And not because you oppose the ability of the government to tax you. There's a specific amendment to the Constitution authorizing them to do it. But it is a violation of the due process of law to deprive you of a fundamental right like the freedom to travel outside of the country, on the grounds that they merely suspect that you might owe them taxes, is an overreaching on the part of the state. It's a striking of the balance in the wrong direction. Every single bureaucrat in the government would like to exercise the power of the state to make their job easier for themselves. So sure, if you're the IRS director, you want to get the monies from the people, say, hey, look how about, if I think you may even owe 25 cents in taxes, how about I revoke your American citizenship? Or how about we kill you with a drone? We might as well, go to our full arsenal here as long as we've got it. Everybody would be offended at that idea. But what you've got to develop, and you need to start developing it now as undergraduates, you've got to develop this kind of hypersensitivity about the invasion of your individual rights. Because the Republican and Democratic Party together now, having this red flag of terrorism waved in their face, are basically cranking down on every single power that the state has. And they're asserting it against people to the point where they've enacted this National Defense Authorization Act, authorizing them to arrest an American citizen based on nothing more than a suspicion on the part of the president or his designee that person has given material support to some organization or individual that has engaged in belligerent action toward the United States. As I mentioned, belligerent action being efforts undertaken to coerce the population to do something contrary to their will, which basically is every demonstration, every march, every strike on the part of a union, all the kind of efforts to coerce a majority of people to do what you want them to do as a minority could be viewed as a belligerent act toward the state. So this is the case that is in front of you now, and as you saw, that the way that the plurality broke on this particular thing is if you want, just look at Powell's decision, Powell's concurring decision, because all you have is a four-person plurality with the White opinion, White and Berger and Blackmun and Rehnquist. But look at Powell's decision. Powell seems to be sounding very reasonable, but what he's saying is that he's striking the balance in favor of the state instead of striking the balance in favor of the individual. So I would recommend you go back and read again that Powell decision, because when he says, look, we're being perfectly reasonable here. And the important thing to remember with the dissent, where they're adamantly asserting that there's a very clear First Amendment right of journalists to protect their confidential news sources, Powell is agreeing with them. Powell says, look, I agree that there's a First Amendment right to protect your confidential news sources. But there's also a right on the part of the state to get the evidence of everybody. And so what we'll do is that we'll recognize that if in fact the journalist, catch this, if the journalist can meet his or her burden and prove that the grand jury has been inappropriately convened or is going fishing for information without reasonable grounds for believing that some crime has been committed, or that there's some kind of prejudice operating behind the impaneling of the grand jury, if the journalist can meet their burden of proving that, then they can get a protective order. You see, he's struck the balance exactly the wrong way, because Douglas, in Stewart's opinions, assert that it is the state that has to meet its burden first of proving the narrow intent of the information it's after, the fact that it's tried every other means and can't get it anywhere else, that it's a very serious crime that's been committed, and unless they get this particular person's information, a serious crime will go unpunished, and there's no other way to solve it. That all of those things have to be met before they can get the information from a journalist. Okay? So the bottom line is that there is a right of journalists to protect their confidential news source, but the challenge is that Powell's concurrence struck the balance in favor of the state. And that one thing that you have to always remember this maxim. If you don't remember anything else from this entire course, do I see your pens flashing to your notes right here? And that is that whenever you get into a balancing test of a fundamental right, the citizen will always lose. Will always lose. Because the state is better equipped to argue how important it is for it to be able to effectuate its objective on behalf of the collective. Always. And so, you know, like Alex Bickel was the professor of constitutional law at Yale Law School. We used to laugh about it, you know, Floyd Abrams and I and others and Floyd had him as his con law guy, that Alex Bickel was able to balance away any right that you could identify. Any right that you could identify. And he would always be willing to put it up onto the scale and start balancing between the state and the individual. And the individual would always lose. Okay? So you want to look to people like Michael John, who was quoted at some length by Douglas. Always go to Michael John if you want to have an understanding of what the proper balance is for fundamental rights. And keep your eye on Douglas's opinions, because they'll tell you. So that's what happened. This was one of the other big fights that was had back in the 60s, and we secured a comparative right on the part of journalists to protect their confidential news sources. In these particular instances, they did not get the evidence from either one of these journalists to try to incriminate the members of the Black Panther Party, either in New Bedford or in Los Angeles. So because they didn't, they ordered them, they said you have to go back, you'll see it at the end of the Pappas case, they said, look, you have to send him back down to the grand jury and let's get a clear idea of what the questions are that are being asked and what kind of efforts they've made to get him from somewhere else. And so what they really did is they resorted almost to the kind of test that Stewart had suggested, and Powell recommended they return Pappas down to the grand jury. And when it became clear that they were fishing in both of those grand juries, they ended up not having to answer those questions. Okay, but the guy in Branzburg did. He had to reveal who the people were that were making the hash down in Kentucky. Okay. So that's that. So look, that's a lot of information. It's a lot of different principles that are flying around here. It's in the context of a very interesting time period. Both of those cases, both those Panther cases are very interesting. The events that were transpiring at the time were very interesting. As I pointed out to you, because of the failure of the lawyers at the Royal Cagle firm on behalf of the New York Times and the Los Angeles Times, arguing on behalf of Earl Caldwell, there was a great deal of dissatisfaction on the part of the legal counsel for the New York Times, James Goodell, with that law firm. And so when they got the Pentagon Papers case, or when they got the Pentagon Papers in June of 1971, they came to us to ask us to represent them rather than Royal Cagle, and we ended up taking the client away from them. And that's the story that we'll talk about on Thursday. But there may be, it's hard, I know, after hearing this much information and many new ideas, to think of questions that you may have, but I would hope that you would have some.
The whole, you were saying that the court was split into liberal and conservative. What do you think, I'm interested in your opinion on like when that happened, or if that had always been there, but there had just not been cases to split them. I'm kind of unfamiliar of like whether that split was already there, or like it was exacerbated by these new cases, or.
Now, what happened is that you have to look to the kind of historical process. Now, it's important to remember that it's in the Constitution itself that the Supreme Court, that members of the Supreme Court will be nominated by the President, and they will be approved by the Judiciary Committee of the Senate, or by the whole Senate, actually. And so that it's understood, the framers understood that the choice was going to be a political choice. So all these people that are appointed to the Supreme Court are appointed for political reasons. And when you're talking about political reasons, you're talking about public policy positions. So that the President and the members of the Senate all have their own preference for public policy positions along this spectrum that I was telling you about. That goes from authoritarian to reactionary, to conservative, to moderate, to liberal, to progressive, to utopian. That there are completely different worldviews in there. And so when you pick a justice and put them on the court, you do it because you have a pretty good idea of what her or his worldview is going to be. And what they're going to do is they're going to bring that worldview to the resolution of this. And so what we saw here, the reason that this becomes so important is because remember, it was in 1968 when I opened the discussion in the first lecture, is when Richard Nixon ended up getting elected president. And Richard Nixon had been the vice president from 1952 all the way to 1960 under Eisenhower. So all of those justices that had been appointed all during that period were appointed by, a lot of them by Republicans, by Eisenhower for 8 straight years. There were still some left over from Truman, and even one from Roosevelt. But what you get, the Democrats and Republicans in general terms, the Democrats tend to be a little more liberal. Republicans tend to be a little more conservative. But what happened in 1968 with Richard Nixon is Richard Nixon had become a reactionary. Not just a conservative, but a reactionary with regard to his issues toward law and order. And he'd gotten so offended at the opponents to the Vietnam War that he, in fact, had started viewing them as ultimate others. And he descended into being a reactionary. And so he would appoint reactionaries to the court, like Rehnquist.
So how many did he appoint?
He ended up appointing, I think, 3 different justices. And all of them were reactionaries. And then what happened is when Ronald Reagan came in 1980, actually 81 January, he elevated Rehnquist from being just an associate justice that had been appointed by Nixon and made him the Chief Justice, which gave him this extreme power of being able to choose to write the opinion whenever he was in the majority. And so he would write these kind of scurrilous, right-wing, reactionary opinions, And so that Rehnquist, I would say if you had to put your finger on where this trouble really started, it was with the appointment of Rehnquist. Rehnquist was a self-conscious reactionary, and he was proud of it. And so he kind of strutted his stuff on the court and started poisoning the well. And then they started recruiting, then they organized a thing called the Federalist Society. The reactionaries organized a thing called the Federalist Society. And they began to organize to get judges appointed. And Rehnquist chaired the committee in the Justice Department. That's where he came from. He was in Richard Nixon's Justice Department, and he chaired the committee picking reactionary judges and filled all the district courts and in courts of appeals with as many reactionaries as they could. And so Rehnquist is, if you had to put your finger on a bad guy here, it's William Rehnquist. And he's the guy. And so and he started writing these kind of strident dissents that were kind of just flaming right-wing ideological tracks. And that's what happened here. So that's what tracks it. Let me, yes, I can't remember, what's the?
Oh, yeah. It's more of just like a random question.
Random is okay.
Do you ever get kind of nervous, like when you're arguing in front of the Supreme Court, even though you've done it so many times?
No, not at all. Because the reason, not because everybody is that way, but the reason that I end up there is because of something that's so important that I really believe in it.
Did you actually argue in front of the Supreme Court?
No, I've been 3 times I've been there. That I wrote the briefs and been present at the court with them, with Floyd Abrams and McKay and actually with Bickle. Bickle was there when I'll tell you all about it in the Pentagon Papers case, because he happened to be there at the office at the Cahill firm working with us on the briefs, because part of the briefs, some of the amicus briefs wanted to establish this balancing test. You know, some of the amici wanted to articulate this balancing test to get the court. They thought that's what the court was going to ultimately do, so they wanted to argue it as well as they could. And so they brought in Bickle, because Bickle can balance away any right that you can identify, right? So Floyd Abrams went and got his con law professor and brought him in from Yale to help write those briefs. And he was there when they brought us the Pentagon Papers case. And so Floyd was very embarrassed about this, and he kept saying, you've got to do something to keep Bickle out of this. I can't do it. He's my professor, you know. And so I'll tell you all about that. That was a very interesting thing. I had a big throwdown with Bickle over this. So, but I don't get nervous. I've argued in front of the courts of appeals and argued in front of district courts and been up in front of the Supreme Court. These are what you have to do. I have to avoid the sports analogy, but the thing is that if you're going to be a good tennis player, you have to be glad to get to be up against somebody really good. I mean, when you're up against somebody really good, you know, you need to light right up. You know, this is terrific. I get to do it. I get to meet a really great competitor here. And so the fact of the matter is that when you're championing particular views and particular objectives as a cause lawyer, you have to relish the idea of getting an opportunity to stand before a court if the court is objective. If the court is an honest court, then you relish the opportunity to get to answer their questions, to get to give them data, to be able to help supply the information that will enable them to make an honest judgment. The problem is if you get in front of basically a kangaroo court, you know, that is completely lopsided one way or the other, and you know that no matter what it is you say to them, you know, they're not going to pay any attention to it. That's not fun. You know, that's the one I think I told you about with Bork, when Robert Bork, after he'd gotten denied coming up on the Supreme Court, I ended up being in front of him, and we'll close with this one for today, is that when we did this case down in Greensboro, which we'll talk about later, I think in the 5th week, where the Ku Klux Klan and American Nazi Party gunned down these 6 anti-Klan demonstrators down on the streets of Greensboro, North Carolina. And the Klan and Nazis were all acquitted by an all-white jury. And so we came in and prosecuted them under the Federal Civil Rights Act civilly. And we wrote a letter to the Attorney General, the new Attorney General that came in under Reagan, and insisted that they appoint a special prosecutor to investigate the misconduct on the part of the Alcohol, Tobacco, and Firearms Division and the FBI. And he didn't respond. In 90 days. And under the Special Prosecutor Act, which was passed after the whole Nixon fiasco, when Richard Nixon fired Archibald Cox, who was the special prosecutor. We'll get to that one too, because that was during the Watergate burglary case, which comes up next week. The Assistant Attorney General refused to fire, actually the Attorney General refused to fire the special prosecutor, and he quit. And then the Assistant Attorney General refused to fire him because Nixon was completely wrong over doing this. And so the guy who ended up firing him was Robert Bork, who was a Deputy Assistant Sub-Attorney General under Nixon. And so when I filed a motion to have a special prosecutor appointed to investigate the misconduct on the part of the government in the Greensboro case, we won in front of Gerhard Gesell, issued a federal order of mandamus commanding the Attorney General to appoint a special prosecutor. The Justice Department appealed it immediately. We went up to a 3-judge panel, and there was Robert Bork chairing the 3-judge panel. So I come in before the D.C. Circuit Court of Appeals, and he looked down at me and he said, "Oh, hello, Mr. Sheehan," he said. And I said, "Well, hello, Judge Bork." And he says, "Well, it's good to see you today here," he said. And I said, "Well, I'm kind of surprised to see you here, Judge Bork." And he said, "Really? Why is that?" I said, "Well, now that you asked, because you're the guy that the whole Special Prosecutor Act had to get passed by Congress because of, because you're the one that fired Archibald Cox, and you're the one that testified in front of Congress in support of passing a special prosecutor. You opposed it. You testified against having a Special Prosecutor Act. So I can't imagine that you're going to sit here having taken a firm position on the unconstitutionality of this act, and you should recuse yourself right now." And one of the other justices said, "Well, Judge Bork isn't on trial here." And I said, "Well, I'm certainly not. We're the ones that have the Court of Appeals the court has ordered you to appoint a special prosecutor." And of course, sure enough, Bork ruled against it. Just like you knew he would, because he's just totally biased about the whole thing. And those kind of arguments aren't fun. Because you have a tendency to have to keep trying to stop whining. Like that. Come on. What about the First Amendment? And you don't want to find yourself in that kind of a position. You want to be actually talking to people that are honest and willing to listen to you. So that's we'll get to that next on Thursday. On Thursday, yes.
Do we have any more time? Or?
Yes.
Okay, I was wondering, in the opinion, they said there's basically no special privilege for the press compared to just a normal citizen for the...
Well, that's what the plurality said.
Yeah.
That's what 4 of the justices said. But in fact, Powell said that wasn't true. He said it's clear that the journalists have some particular right and he said, "That's why I'm writing this concurrence. I want to make it clear that when you really listen, there is a right that the journalists have that others don't have, because there's a degree of interest to keep the free press free, and if you can show that in fact there's going to be chilling on the free press, and you can also meet your burden of showing that they're on a fishing expedition and they don't have any specific evidence that there's any crime committed at all, and they haven't made any effort to really get it from anywhere else other than you, and they're trying to transform you into an investigator for the police, then you have a right that others wouldn't have to get a motion to quash."
It seemed like the logic there was that since there are exceptions to free speech for private citizens, there's obviously exceptions for what we should restrict on the press.
Before answering, I just want to, we can't keep everybody, so maybe you two, you can have a nice dialogue after.
Well, let me just finish this. That the thing the beauty of Powell's concurrence is that he specifically states that there is in fact some degree of special privilege that a journalist has when called before a grand jury, that they can in fact invoke certain types of interests that other citizens cannot. And he agrees that they can't do it if they are the ones charged with crime, or if they have direct proof of having witnessed someone commit a crime in their presence. He says that privilege won't go to that extent. You don't have the right to refrain from talking about that. But if you can show that they're attempting to transpose you into an investigative arm of the state, and they don't have probable cause to believe that any specific crime has been committed, but they're fishing, then a journalist, unlike another person, a regular person, wouldn't be able to invoke that. They'd have to answer it no matter how much fishing was going on. Okay, so there is this narrow right that Powell has admitted that they have. Okay?
Next week.
Or next Thursday.
Thursday.
Okay?
Is Anthony Luca here? Okay, great. Just wanted to chat with you, Anthony.
Okay? All right, kids. Thank you, thank you.